Hi, all, welcome back to the Commerce Code. So, today we are going to deal with 20 important doctrines that are relevant for your UGC NET Law exam, that is your paper 2. Right, let's get started. So, the very first doctrine is basic structure doctrine. So, this is something which we are all familiar with, right? So, the parliament has no right to amend the constitution if it affects the basic structure or the basic features of the constitution, say democracy, secularism, judicial review, etc. And again, this doctrine was put up in the case of Keshavan Bharati versus State of Kerala. Now, moving on to the second doctrine. The second one is doctrine of harmonious construction. So, according to this particular doctrine, it says that whenever two provisions or two acts or statutes contradict each other, it is important to note that the court shall only interpret that in a way that gives effect to both of these statutes or provisions. That is, one shall not be avoided for the benefit of the other. So, both should be given equal importance. Now, moving on to the third doctrine, that is doctrine of eclipse. This is very important from the point of view of Article 13 of the Indian Constitution, right? So, it says that if it is found that any pre-constitutional law is inconsistent with today's fundamental right, that is Part 3 of the Constitution, then it is not completely void. Rather, that will be eclipsed or it will be shadowed by today's fundamental right. Okay, so that means that the old law will not be considered to be void, rather, it will be shadowed by the fundamental rights. Next is the doctrine of pith and substance. This doctrine says that whenever we are trying to interpret a law, its true nature and purpose should be considered. So, this helps court decide if a law falls within a legislative competence by focusing on its essence or dominant objective rather than incidental, minor, or encroachments on subjects outside its jurisdiction. So, the intention of that particular law should be considered. Now, moving on to the next doctrine, that is doctrine of severability. Again, this is very important from the point of view of Article 13 of the Indian Constitution. So, this doctrine says that whenever there is an inconsistent part to a provision or inconsistent part to a statute, or say there is an unconstitutional part in a law, that can be struck down if separable from the valid portion. That is, from an entire law, this invalid portion can only be taken away, keeping rest of the act still valid. Okay. Next is doctrine of colorable legislation. It says that legislatures cannot do things that are directly prohibited to them, even in an indirect way, though it is legal or illegal. Right. Next doctrine is doctrine of territorial nexus. This states that a state legislature's law, generally limited to its own territory, can apply extraterritorially also if a real connection exists between the state and the object, person, or transaction in that particular question. Next is doctrine of incidental or ancillary powers. So this doctrine says that when a legislature has authority over a particular subject, it also has the authority or power to legislate on matters incidental or ancillary to that particular subject so that it can ensure effective implementation of that particular law. Next is doctrine of repugnancy. It says that if at all there comes a situation where there is a conflict between the central law and the state law, but on a subject matter that is listed in the concurrent list, then the central law prevails over the state law. Next is doctrine of pleasure. So, if you have studied the provisions of Attorney General or Advocate General, you can see that it is said an attorney general can hold office during the pleasure of the president, that is the tenure or the pleasure of the president. So the president or governor can remove civil servants at pleasure subject to constitutional limits. So it always shows a tenure or the time period for which a civil servant can hold office, and that is based on the pleasure of president or the governor. Next is doctrine of proportionality. It basically says that it is a principle ensuring that administrative or legislative actions are not excessive, and it maintains a balanced relationship between the means used and the objectives pursued. So it is often summarized by the metaphor that steam hammer should not be used to crack a nut if a nutcracker is sufficient. That is, the action and the objective should actually go in par. Next is doctrine of lectures, which basically says that a delay in seeking remedy bars relief if it prejudices the other party. Moving on to the 14th one, that is doctrine of necessity. It says that in an emergency situation where there exists no any other alternatives, then an authority can actually decide its own case by itself. Now, moving on to the 15th one, that is doctrine of audi alteram partem, which is a part of natural justice principle, which says that before deciding a particular case, the judge or the court shall hear both sides before coming to a conclusion. Okay. Next is the doctrine of judicial review, which is very important and is also a basic structure. It is the power of the judiciary to examine the constitutionality of legislative enactments, executive orders, and administrative actions. So, if any action is found to be inconsistent with the constitution, the courts can actually declare it to be null and void. Next is doctrine of res judicata. It basically says that if at all a case or a dispute has been finally decided by a court of law, then it cannot be reopened again or with the same party for the same relief and for the same subject matter. Next is the doctrine of public trust. This is a legal principle establishing that certain natural resources like air, water, and forest are too important for private ownership and must be held by the government in a sacred trust for the benefit of the general public. So, under this doctrine, the state is not an absolute owner of a of these resources, but a fiduciary or a trustee, while the citizens are the beneficiaries. Next is the doctrine of parens parte, which is a Latin term which basically means parent of the nation. And this is a legal principle that empowers the state or the courts to act as the guardian of the individuals who are unable to take care of them themselves. Okay, so the last doctrine for this particular session is doctrine of stare decisis, and this is a fundamental legal principle requiring courts to follow precedent set by previous higher courts decision in similar cases, translating to stand by things decided. That's all for today. So if you need a detailed lecture or notes, please feel free to contact us in the below number. Thank you.